Ngayong araw nilagdaan ni Pangulong Rodrigo Duterte ang Republic Act number 11479 o ito ngay mas
people question the timing of the bill.
But given the country's long and brutal experience with violent extremists, why the public outrage over something that's supposed to help the common good?
Payo naman ng National Union of People's Lawyers, maging mapagmasid at tutulan ang anumang pagmamalabis.
Welcome to the inaugural episode of The Reasonable Doubt. So, Attorney EM, what is this podcast all about?
The idea behind this podcast is to discuss issues, legal issues, and how it affects our daily lives. How things that are happening right now would affect us legally.
And for this inaugural episode, we have a guest. And our guest, Attorney EM, is Attorney Mayor. We are going to talk about human rights in the time of pandemic, about arrest. My first question is that, what is an arrest? What does the Constitution, the 1987 Constitution, say about arrest?
Our Constitution, in the 1987 Constitution, it talks about protection against unreasonable searches and seizures. So basically, under our Bill of Rights, we have that right to be free from any unreasonable search or seizure. Not exactly arrest. Under our Constitution, a person can be arrested or his property searched or his self or is being searched, provided that it must be reasonable and that there must be basis for it. There are two types of valid arrest under the Constitution. First is that an arrest made with a warrant, and the other will be a valid warrantless arrest. The requirements of a valid warrant of arrest is that there must be probable cause, which is determined by a judge who has jurisdiction over the case, and that probable cause must be based on pieces of evidence or the oath by the witnesses presented.
For a person to be arrested, first, the most valid one it was known is that there must be a warrant of arrest. And to be able to do so, you must avail through before a judge, a competent judge. Evidences must be submitted. Doesn't necessarily to be that of preponderance or only sufficient evidence so as to give the judge a probable cause that this man needs to be arrested, that this person needs to be arrested. This is why the police, before arresting someone, needs to procure or to present evidence before the competent judge that this person needs to be arrested because he has committed a crime or they have other reasons for him to be arrested. That is why protection that is enshrined in the Constitution that before a person can be arrested, one must have a valid warrant of arrest, must be issued by a judge because only the judges can determine if there is a probable cause for a person to be arrested.
According to the 1987 Constitution, it is the sole duty of the judge to determine probable cause. I mean, in terms of constitutional history, talaga bang judge lang ang nagde-determine sa probable cause? And natanong ko to since kaakibat siya nung recent issue about the anti-terror law, di ba? Kasi under the anti-terror law, it appears doon na hindi lang judge yung pwedeng mag-determine ng probable cause. Because under the anti-terror law, an agency, di ba, the Anti-Terror Council can issue a warrant of arrest against suspected terrorists. So, Attorney M, can you go us through doon at least sa constitutional history?
Say, our Bill of Rights, it is the list of our most fundamental rights. So basically, who decides kung ano yung most fundamental rights ng mga citizens? It is the drafters ng Constitution, and usually, what they do is they base it on their own personal experience. Kaya nga, when we look at the concept of unreasonable arrest, when they drafted that provision, it was lifted from the 1973 Philippine Constitution, except that they removed a certain sentence from the 1973 Constitution, which is that under the 1973 Constitution, it included other persons authorized by law to can issue warrants of arrest. This power, this provision in the 1973 Constitution was the basis for the issuance of yung mga ASO, yung Arrest, Search and Seizure Orders na ang nag-i-issue is yung Secretary of Defense. Kasi inauthorized siya under the law, under General Order number 2. He was authorized to arrest certain individuals.
And this is in the context of martial law.
Yes, in the context of martial law. That is the 1973 Constitution. So, when they drafted our current Constitution, isa yun sa mga tinanggal nila na provision that they willingly remove para ma-avoid na yung danger ng abuse with regards to arrest. Kasi, if you still have that provision, the legislative can just create past laws that would designate certain persons or authorize certain persons to issue warrants of arrest. Kasi, the belief under the Constitution is that yung issuance ng warrants of arrest, that is a function of the judiciary kasi. So, it should be only judges who are under the judiciary who should issue warrants of arrest.
So, attorney, so klaro tayo doon, di ba? That in terms of the intent of the framers of the 1987 Constitution, there is really the intent to make it exclusive for the judge to issue a warrant of arrest. Diba? There's no other person can issue a warrant of arrest or can determine probable cause except the judge. Meron tayong the anti-terror law, diba? At sinasabi doon that the anti-terror council can determine probable cause, can issue warrant of arrest based on their determination of a probable cause against suspected terrorists. So, Attorney Mayor, given that, what can you say about that particular provision of the anti-terror law?
With regards to that particular provision, it may be stated that on its face, it is unconstitutional. But however, the Constitution cannot, or we cannot really declare that it is unconstitutional because it's already been enacted into law. That is why, before someone can have it said that it is unconstitutional, it must be declared by the Supreme Court. So, unless it has been declared, this provision of the anti-terror bill remains valid. So it's still enforceable. The only thing that they're doing now is to enacting the guidelines, the internal rules, no,
Implementing
for
rules,
the implementing rules of the anti-terror bill. And also the formation of the committee and everything else that the law will be, the purpose of the law to be enacted.
Thank you, Attorney Mayor. Pero Attorney M, di ba, meron ng mga petitions ngayon, di ba? There are multiple petitions filed in the Supreme Court asking for the Supreme Court to declare that some provisions the anti-terror law are actually unconstitutional. And one of these provisions, yung sinasabi nga natin about dun sa issuance, what can you say about these petitions right now in the Supreme Court? Do they have a strong legal basis, especially na wala pang direct injury, wala pang may justiciability na ba, justiciable na ba yung issues na to that the Supreme Court can take cognizance of this case?
I think it is recognizable na by the Supreme Court. And this is only my opinion naman. I don't even presume to substitute my wisdom to that of the Supreme Court. But I think with regards to this matter, to this issue, it is so transcendent that certain procedural aspects of filing this petition can be overlooked by the Constitution. I am hoping na sana kapag dinesisyonan siya, there is a full discussion on the merits of the case and not just rely on technical grounds for whatever purpose kung i-dismiss nila or i-grant. So, personally, I'm looking forward to the discussions of the Supreme Court with regards to this law. I think it's going to be very educational for us lawyers then.
The bench and the bar.
Okay, ayun na nga, Attorney Mayor, di ba? What can you say? Sinabi ni Attorney EM na parang he is looking at the transcendental aspect of the law, di ba? That the Supreme Court can set aside certain procedural rules, di ba? How about yung sinasabi nila dito about sa facial challenge ng statute, di ba? May sinasabi sila doon na parang there's no need for a direct injury. The court can take cognizance of this case based facially. Ano po yung ibig sabihin nun?
Well,
At least para sa mga
facial challenge, ito yung natatandaan ko sa political law namin. Pag sinabi kasi facial challenge on its face, so when the law on its face is deemed to be unconstitutional or there are provisions that would impede substantive rights, there being no need to be a private complainant or someone who has been injured or someone that has already been affected by the said provision, there is no need for that because when the provision itself can be challenged facially on its face, then it can be taken cognizance by the courts.
Okay, that's true, no? Ako naman, ang tingin ko naman dito, di ba? Since that particular provisions of the anti-terror law can actually have a chilling effect, especially sa mga critique, ng government, di ba? Since may chilling effect siya sa mga critique ng government, then that can be the basis of the facial challenge, di ba? So, let's go back sa arrest. Okay, nag-issue ng warrant of arrest yung judge. Now, my question is that kapag ikaw yung ina-aresto, ano ba yung process ng pag-arrest? Parang kung ikaw ina-aresto, ano yung kailangan mong gawin para maprotektahan mo yung mga karapatan mo during the arrest? Attorney Mayor?
Well, first, pag ganyan, make sure na ito sa ano lang naman ito. Let's see kapag ito ay mayroong valid warrant. If there's a valid warrant, first of all, you better make sure that the persons arresting you are truly law enforcers, no? Police officers. No? They should be in uniform, proper attire, and they should address themselves as such law officers. Next is that you ask for the warrant. If they're asking that you are to be arrested, then you ask for a warrant. and then you clarify and you look through that warrant of the arrest if it is indeed the person that is indicated in the said warrant is actually you. Now, if it is, then certain rights must be provided. Let's just say if you're going to be arrested, the law enforcer should inform you of your rights, the Miranda rights or Miranda rights na sinasabi. So everything the basic. So you have to remain silent, the right to counsel. Those are the works. Then, of course, necessary restraint. No, it does not include that you need to be handcuffed immediately. No, if you are willing to go with them, then there's no need for an excessive restraint. Well, that would be a violation on their part. Preferably, you should, if everything is valid, if everything the police officers have done is valid, they're on point, they're on procedure, but the person should remain calm. It is highly suggested that favorable that he or the person should cooperate. Yes, cooperate and do not escalate the matter. He should cooperate with them, and then when he's already when the person is already at the precinct, I could ask or call for the lawyer before everything else, over any other procedures. By that time, he is already entitled for bail. However, that's not the sa warrant meron na eh. So nandun na yung
may information na eh.
There's already the warrant.
We perhaps we are going to talk about bail later on. Pero Attorney EM, any additional on that guidelines? But before you answer, no, may ma-share lang ako na isang situations that I actually read on Twitter. Kasi I read a tweet, parang sinasabi doon na parang isang karapatan, member or officer ng karapatan, tapos may kumatok sa bahay niya na naka-LBC, yes, di ba? Naka-LBC na uniform, tapos nung binuksan niya, nagpakilala yung tao na yon na pulis at nag-abot sa kanya na warrant of arrest. Given that, sa sitwasyon ba na yun, may mga violation, and if may violation, ano yung dapat gawin ng inaaresto? For instance, nung karapatan officer na yon, at Attorney EM, what do you think?
Based nga sa discussion ni Attorney Mayor kanina is that the person should ideally be in uniform, the arresting officer should be in uniform, and the word set. Doon sa situation na yun, ay in-explain nga rin sa kanya ng mga police officers that they usually do that kapag to ensure that the arrest will be made. I think that is an acceptable deviation naman, provided that all your rights will still be read to you. Babasahan ka pa din ng Miranda rights mo, and everything will be explained, and that the arrest is proper. I mean, may proper warrant of arrest. Because I tend to agree, in that case, I tend to agree with the police officers na if they try to arrest everyone na utilize those kind of schemes, mahihirapan talaga sila mag-arrest, ng arrest nila. I think din kasi medyo exceptional din yung case na yon, especially sa legal setting sa Philippines, na bago ka naman sumission ng warrant of arrest, usually alam mo na may kaso ka eh. Dahil na-file lang na sa fiscal level eh. In that case, yung sa LBC, I think that it's okay naman. It's okay. Valid pa rin yung arrest.
Attorney Mayor, parang gusto ko lang balikan yung sinabi mo about yung sa proper demeanor. Parang kung ikaw yung inaaresto, ano yung tamang frame of mind, tamang behavior, yung ideal behavior na dapat mo ipakita during inaaresto ka? Kailangan mo ba maging hysterical, magdala ka ng 1987 Constitution, tapos basahan mo yung police? Is that the ideal way to handle that? What do you think?
Hindi. Sa lahat nga ng situation, it's better to remain calm because that is the time that you need to think. Now, if you're being hysterical, if you're being pressured by the situation, you cannot think carefully. Possible is you might utter something that might incriminate you. So you better just stay silent, remain calm, and just, if you have a lawyer, go talk to your lawyer, have him communicate with your lawyer so that you'll be advised on what to do on certain situations and what are the procedures. Kasi there are a lot of instances that when a person is arrested, they always uncooperate or always has hysterical, and they didn't want to cooperate. They would drop names. They would even oppose the law enforcers, and that would not do you good because it would only add additional penalties if you happen to assault the law enforcers
or offer a bribe.
At least klaro tayo dyan, di ba? Parang there's a need to calm and call your lawyer. So that is for the arrest, di ba? Based on the issuance of a valid warrant of arrest. Now let's proceed to warrantless arrest. Attorney EM, what is warrantless arrest? What are the types of warrantless arrest? And ano yung kaibahan niya dun sa arrest based on a judicially issued warrant of arrest?
To discuss this, we should put it into a context. Something na a couple of months ago, diba, sinabi ni Senator Soto at si Senate President, he asked na, paano kung may terrorista, tapos may suot na suicide vest, hihintayin pa ba may issue ng warrant of arrest bago mo hulihin? And I think that the good senator, may have forgotten the concept of a warrantless arrest, wherein our law enforcement officers can actually make arrests even if there is no warrant. That it falls within the provisions of the law, which is yung unang type niyan is that if an offense or a crime is being committed in your presence, if a crime has just been committed, is being committed, or is being attempted in your presence, then the law, that's the first type of warrantless arrest. Then the law enforcement officer can effect arrest at that moment. So yun ba, sa question na, pag may nakita ka ng suicide vest, do you have to ask for a warrant? Of course not. Kasi a crime is being committed in your presence, and the law enforcement officer can make that arrest na. Ang second type is that based on your personal knowledge, a crime has just been committed, and based on your personal knowledge, the person to be arrested is the one who committed it. So yun, that's the second type. And yung third, yung mga escapees sa prison. You don't need a warrant of arrest to arrest yung mga escapees na from prison.
Okay, so siguro kaakibat ng issue ng warrantless arrest yung another issue of a citizen arrest. Diba? So, Attorney Mayor, ano ba tong citizen arrest? Parang, is it an offshoot of a warrantless of arrest? Sinasabi ba natin dito sa citizen arrest na kapag ordinaryong citizen ka, kaya mong may kapangyarihan kang arestuhin yung isang tao na gumagawa ng krimen?
Yes, it's already included in the law that citizen, kasi it does not necessarily said that only the law enforcers may execute a warrantless arrest. It also include other persons, civilians basically. So if a crime is being committed in their presence, actually being committed, is about to be was being committed, they may actually execute a citizen arrest. Yun yung tinatawag na citizen's arrest because they are also capable or they have been deputized by the law itself to make the necessary arrest. Pag nagawa nila yun, they have, next step is that they should call or communicate with the nearest or someone that the law enforcers that is within the vicinity. They have to make the necessary transfer, surrender of the said person to the said person of authority.
Alright, so but my question is that, for instance, a citizen failed to arrest a person committing a crime in his presence, does it have any legal implications sa kanya? Meron ba?
No, wala naman.
There's
no malfeasance or, tama ba ang term ko? Malfeasance or malfeasance, no?
Mm-hmm.
Misfeasance on his part because he is not obliged or is not obligated to do the arrest.
Okay. Mm-hmm. So parang there's no positive legal duty for ordinary citizens to arrest a person committing a crime in his presence, di ba? So,
yes.
Siguro yung next topic natin dito is that kapag na-aresto ka na, tapos iniimbestigahan ka na, tapos nagtatanong na sa'yo about sa crime, perhaps ito yung issue ng custodial investigation. So, may kaso na nangyari para months ago kung saan may mga netizen nag-post ng mga valid criticisms against the government, and the NBI invited them. Is that friendly questioning made by NBI? Is it considered an arrest or is it a custodial? Given that context, given that story, ano ba yung mga rights ng isang ordinaryong tao kapag inimbitahan ka ng NBI or ng PNP for a friendly questioning or investigation?
Hindi ko ba alala lang yung exact terms, pero that falls under custodial investigation. When law enforcement officers invites you for questioning, pag-uusap lang, and yung mga ganyan terms, you already have the right, at that point, dapat, basahan ka na din nila na they have the right to remain silent. They should inform you of your rights at that point, and that you should be given a lawyer, or you should be allowed access to your lawyer. Para lang, anything that you say at that point you should be advised kung may criminal liability ba yung mga sinasabi mo at that point. Yun.
Okay, Attorney Mayor, ano ba yung test para malaman natin kung custodial investigation na yung nangyayari or ano lang, simpleng friendly invites lang sa pulis?
Mahirap sabihin na yung friendly invites na yan because ang daming in my practice, ang daming nadali dyan sa simpleng invitation. Barangay lang invited by the barangay and then everything escalated so quickly, nasa pulis ka na and then you're already detained. Simply because a custodial investigation is differentiated to an inquiry or to an inquiry because in custodial investigation there is already a particular person, there's already a particular suspect, and that is the one that's being invited. In a general inquiry, wala pa, there's only a suspecha pa lang, so there's no need for you to be placed in or to be brought to the police station if that is the purpose of the police officers, is that to inquire. So they can inquire you at your house, outside your house, in your residence, that's it. Custodial investigation, on the other hand, there's already particular suspect, and if it is you, the one that they're going to invite, you're the particular suspect. So there is no longer a general inquiry inquiring on what did you do on that day or the matters concerning the matters in relation to the crime that is being investigated. At that point, as what my colleague has stated, you should be given, or your Miranda rights should be said to you. The right to remain silent, the competent counsel, all of which must be provided before custodial investigation may proceed. So those are the differences.
Okay. So merong isang hypothetical scenario. For instance, ako in-invite ako ng barangay, tapos tinanong ako kung pinatay ko daw ba yung suspect or kilala ko ba yung suspect. Tapos what if sinabi ko doon in the presence of barangay, inamin ko sa kanya na yes, ako po yung pumatay sa suspect. Yung meeting, kapag barangay nag-invite sa'yo, tapos yung barangay nag-interrogate sa'yo, tapos in the course of interrogation, umamin ka na ikaw pala yung may sala, is it already a violation of your rights during custodial investigation? Or it is a valid extrajudicial or
admission.
Confession? Yes, admission.
To be valid judicial, sinasabi nila natin extrajudicial because it is made outside the courts. It must be made in
free
writing, free from any from any duress, and you must have with you in the presence of your counsel. Without counsel, your extrajudicial confession will not hold water, or still subject to contest, or may still be may be reverted. So it cannot be held against you, or it cannot be used against you, because yun nga, nasa Miranda rights you have the right to remain silent. So if anything you say, so long as meron kang counsel with you, it may be used against you. If there's no counsel to guide you or to advise you on the matter, and you may utter things, those things cannot be used against you. No?
Okay.
Those are self-implement.
So, siguro i-discuss natin yung kaso against dun sa teacher. Some criminal charges were filed against him, such as inciting to sedition because of his tweets na seditious daw. Tapos, as far as I know, it was dismissed. The case was dismissed based on procedural grounds. Kung nasundan niyo po yung kaso, what can you say about that? May mga mali ba talaga yung NBI doon sa nangyari? Especially, di ba, Attorney M, mukhang sinasabi ng NBI na nag-confess naman daw yung teacher sa harap ng media.
Yeah. I think, if I remember correctly, yung decision doon, it was quashed tama ba? Yeah, I think it was quashed by the court based on the illegality of the arrest. Kasi warrantless arrest siya. Ginawa, hindi naman sila nag-apply for a valid warrant. And that, ang sabi kasi yung findings kasi ng prosecutor is that the confession made by the accused, yung teacher, to the media, di ba, in-interview siya ng media and everything, is that it cured the defects of the arrest. And the court said, hindi, that's not, that cannot cure the defects in the arrest, especially kasi under detention na siya when he made that confession. So yun. Pero yun.
I guess 'di ba yung media interview nangyari inside the PNP
NBI.
Headquarters, NBI, 'di ba? Parang within the establishment. So the fact that you are inside the establishment, it means that you are already being detained. 'Di ba?
Yeah.
Attorney Mayor, meron ka bang additional on in that particular case dun sa teacher?
Same lang din naman.
Sa-
Sige, ano yun? Ulit.
How about dun sa sa charges niya inciting to sedition?
Inciting
Meron
sedition.
ba? Given the fact na may anti-terror law na, kailangan ba natin mag-ingat sa mga pinopost natin sa Twitter, sa social media kapag against yung mga criticisms natin against sa gobyerno? Dapat ba tayo matakot, Attorney Mayor?
Well, for me, yes, we should be very careful on what we post online, especially if it concerns the government. No, we do not know how do they plan to use the law. Right now, what they're saying is that they are not going to abuse it and they will only be using it to track down terrorists and all those that are affiliated with the terrorist groups. Those that are in the legal fronts, the ones that are supporting them, they'll be using that said law to confront those legal fronts. So that's why they need that law. However, prior to the enactment of the said anti-terror law, you could see how the NBI operate on dissenters or somewhat citizens that are expressing their dissent, or let's just say that they might impose posts that are somewhat on the bounds of criminal liability. However, in almost in all instances, the intention was merely to express their dissent, not really to do, not really their intention is to express a threat, or to incite sedition. So that's the problem. If those kinds of news, we hear that the persons or that the law enforcement agency are tracking down these kinds of person on a whim, basically, there would be that so-called chilling effect that other persons will also think twice in expressing their opinions or their dissent to the current situation that the government is handling. So, yeah, I could say that it would be very, we could say, troubling the anti-terror law.
Oo nga, parang given this kind of environment, having an anti-terror law, di ba? Parang it chills people, it has a chilling effect. It can be a deterrent for people to express their valid dissent against the government. But Attorney EM, given that kind of danger, but still expressing dissent is our constitutional duty, di ba, as citizens. So, kung ikaw yung ordinaryong mamamayan, dapat bang matakot ka? At kung matakot ka man or kapag inaresto ka, ano yung mga legal remedies na available for you?
Well, this is something na tinanong din naman, a couple students asked me this question din eh. What are the remedies under the new law? First, sabi ko, and related to this, sabi ko sa kanila, you should be smart with what you are posting. Know your rights, know the boundaries of your rights, and remain there. So, be careful. Maging careful lang tayo pag nag-post. Let us make sure na it is within our freedom. Na we do not overstep it. Kasi nga, based on the current climate, any overstep kasi, or even kahit hindi ka mag-overstep, posible nga na ma-arrest ka. Or that you may be prosecuted for something. And the best defense there kasi is to prove that it is within your right, it is within your freedom of expression. And that if the post is against the government, it is a valid criticism of the government, which is allowed under the law. And actually, it is our duty nga. Sabi mo nga, Kuya Emil, it's not only our right, but also our duty to present valid criticisms and to take part in discussions on public issues as citizens of the country. Yun.
Alright. So, perhaps for our last topic, let's talk about the issue of checkpoints, di ba? Kasi given this pandemic, di ba, with ECQ, GCQs, ang daming checkpoints. And on these checkpoints, ano yung mga karapatan ng isang may-ari ng sasakyan, ng isang motorista during checkpoints? Ano yung dapat na maging demeanor niya during checkpoints? At paano ba inaabuso ng mga law enforcement agencies yung kapangyarihan nila sa mga ganitong setting? Perhaps, Attorney Mayor, mag-start tayo dun sa checkpoint, diba? Kunyari, may sasakyan ka, hinarang ka sa checkpoint, ano yung mga dapat mong gawin? Maunang dapat mong gawin in that kind of situation?
Well, first of all, yung mga checkpoints, the checkpoints were there just to impede transportation of people, no? Because that's how the virus works, no? So make the situation in the pandemic. The checkpoints were there so as to impede or to obstruct the unnecessary travel or travel of persons or carriers, possible carriers. So they have the IATF imposed guidelines or who are allowed to travel. So that's the first. Before you could travel, you must be authorized to do so. You know that you are within the guidelines. You follow the guidelines. So if you're within those persons that are allowed to travel, essential travels, you need to go to the hospital, you're a doctor, a lawyer, police officer, then checkpoints should not, or the persons there should not impede your transportation or your egress or egress. So the next thing is to check is if right now that was during ECQ, but right now we are already at general community quarantine, and there has been a relaxation of the travel restrictions. So mostly you can now go outside. The problem is going to other towns or other provinces. So that's there lies the problem, because the IATF has now imposed or did not really designate what are the things to be done between these provinces, because each provinces and each local municipalities they can impose their own restrictions. Just like here in Tanay, we have Tanay in Barangay Sampaloc. None of the riders there cannot go inside or outside Barangay Sampaloc because it is in their barangay ordinance. They're very strict. They cannot, they won't allow any persons that are
Not president.
exempted. That are not exempted, or they don't have even essential travels, non-essential travels that just passing through their barangay. Also in Sagada Mountain Province, if you have heard the news, they denied the media team of Malacanang to conduct a shooting for the, I do believe that is for the State of the Nation address film.
Pero Attorney Mayor, my question is that kapag hinarang ka sa checkpoint at pinababa ka ng law enforcement agency, may karapatan ka bang hindi bumaba, or may karapatan ka bang sabihin sa law enforcement agency that I have a right of privacy within my vehicle? Then secondly, my second question is that what is the limitation in terms of search? To what extent lang yung pwedeng gawin na search ng law enforcement agency during a checkpoint?
This does not include now. This particular checkpoint is not specific or not particular with the current pandemic.
Yes.
This is checkpoint. This is checkpoints in general. Therefore, pag checkpoints, you cannot be compelled to step out of the vehicle. No. That is valid. That is the first thing that the officers conducting checkpoint must respect. Now, they cannot oblige you to get out of the vehicle. Although they can allow, they can request for you to close down your window, but they cannot force you to compel you to get out of your vehicle. Also, the allowable search is that it is sabi nila plain view. So they cannot compel you also to open any of necessary compartments from your car, from the vehicle. They can only search it within the plain sight. So yung iba, so the proper way to do it is to just look from the outside. So look from the outside. If they have flashlights, it is allowed.
So,
That's only the allowable search.
Attorney Mayor, what if yung law enforcement agency is actually insisting that you get out of the vehicle? In that particular kinds of situations na nag-insist in law enforcement agency, what's the best way to handle that?
Just always to remain calm, and still, pag bawal, you don't have to go outside. It will be more danger to you if you went outside of the vehicle, because they could, these are the possible situations that when you are outside of the vehicle, other persons might try to invade or look and peer inside of your vehicle and might put something there that might incriminate you. So it is better still that even if you're being compelled to, or they're forcing you, that you should still stay inside your vehicle. That is the number one. They cannot force you out of it, or if they do, they would be liable criminally, administratively.
Okay. Pero what if you freely went out? Meaning to say, hindi ka pumayag ka. Is it a waiver of your right? May mga legal implications ba yan? Kunyari, sinabi lang ng law enforcement agency na going to conduct a plain view search of your vehicle, pero ikaw bumaba ka, tapos nung nag-search sila, hindi ka tumanggi. Is that a waiver of your rights? And in that particular situations, ano ba yan? May legal implications ba yan in terms of your right against unreasonable search and seizure?
I think it would also, in my opinion lang, I will just correlate it with the extrajudicial confession, no? Supposedly, if you went outside on your own without any, given the circumstance that they are not forcing you, the police officers' demeanor are kind, they're polite. They didn't even ask you to get out of the vehicle. You just went out of the vehicle and just strolled around the vehicle. If that's the circumstances, then it would mean that you have opted to waive such right, that they cannot compel you outside. However, still plain view applies. They cannot go inside, they cannot peer inside your vehicle. They can only still have a flashlight, look through the outside, even if the door is open. And that's plain view pa rin. They cannot go inside, they cannot have their body or head inside the vehicle.
Pero how about you? Can they frisk you? Pwede ka bang kapkapan in that particular setup? Hindi pa rin.
Hindi pa rin. Yung stop and frisk doctrine naman, papasok yan if there is if the police officer has reasonable doubt based on his personal knowledge and experience that the person to be frisked has committed a crime or might commit a crime or exhibiting criminal demeanor. No? If not, tulad nga sa checkpoint, biglaan ka lang i-frisk, hindi pwede.
Okay, so at least klaro tayo dun, no? Okay, attorney.
No, actually, there's another thing yung ginagawa na they would ask you yung consented search.
Yeah, so, consented search. That's
so if you are in that situation, dapat alam mo yung rights mo. Kaya nga, diba sabi natin kanina, you should know your rights. Para pag ano sa situation na yun, if they ask you if you would allow yourself to be frisked or if your vehicle to be searched, you would know na pag nag-yes ka na, that is already a consented search and it is allowed. So, dapat, dapat knowledgeable ka na you can say no to that.
I guess tama yung sinasabi mo, Attorney EM. So kapag nag-insist pa rin yung law enforcement agency, you can say sa law enforcement agency that, okay, you can freeze me, but let me point it out that I am not consenting this freeze. Diba? So in that particular situation, since delikado rin, diba? Kung magre-resist ka kasi sa kanya, baka may gawin siya sa yung masama. So, I think the most prudent, the better way to handle that is to say categorically that you are not consenting on this freeze, on this search. But if they insist, then go on. But at least klaro na klaro that you do not waive your right, di ba? So, meron pa ba tayong nakalimutan? Okay, naalala ko na. How about kapag motorcycle ka, motorsiklo? Kasi nakikita ko sa mga checkpoint, di ba? Pinapababa, tapos binubuksan yung upuan, tapos tinatanggal yung helmet. Ano ba to? Is it the same law is it the same rules kapag vehicles, PUBs, PUJ, or kapag motorcycle, or magkaiba bang rules dyan? What do you think? Kasi ako talaga, nakikita ko talaga bakit binubuksan.
Ako din, this is something personally that I am curious din kung bakit motor lang yung pinapawa ngayon sa mga checkpoints. So,
kawawa mga nagmo-motor. Actually, yung sa consented search, pwedeng dyan pumasok, batch, di ba? If pumayag kang bumaba, consented search na rin siya. Kasi if pumayag kang bumaba, then that's it. It's a waiver na rin if you don't want, di ba? If every checkpoint, bumaba ka, alam mo na yung protocol, sasabihin sa'yo ng police that we need to see your the compartment. Bumaba ka, inano mo, okay lang. Then that's a consented search. Now, if you don't want to, alis ka. Pwede kang bumalik doon. Huwag kang dumaan sa checkpoint. However, you'd raise suspicion naman on the part of the police officers.
Yeah, tama.
So, it's a double whammy.
may isa din possibility kasi, pag ginanapan ka ng ORCR kasi, ng vehicle, pag motor kasi usually doon sa compartment sa
Correct.
Yes,
mababa ka talaga.
that's the common na ginagawa talaga.
Baka ganun talaga yung nangyayari, di ba?
Yeah,
Kaya nakikita natin na binubuksan kasi hinahanap nila yung ORCR, but not necessarily the law enforcement agency searching something inside sa di ba? So, at least klaro tayo doon, na kahit nakamotor ka, kahit naka-PUVs ka, or kahit naka-PUJ ka, your right against search, your right against unreasonable search and seizure are still the same. Yeah. Walang double, it does not yung batas natin does not discriminate kung naka-motorcycle ka. So, you can still say no, di ba, sa mga searches, and you still have your right to privacy, and they should still follow their guidelines. For our last words, and Attorney Mayor, given what transpired in our short conversation, can you give us your last words, or probably let's summarize what we discussed in this short podcast?
Siyempre, lang naman, let's go back again. When it comes to being arrested, remain calm, contact your lawyer immediately so that you know how to assess the situation and how to proceed with the situation. With regards to the anti-terror law, be very careful when posting and expressing your dissent or your criticism with the government, because it might be interpreted or misinterpreted by the council. Know of what is there, even if it is on its face. That's the problem. Even if it's on its face that it is valid within the law, they may still have you issued a warrant of arrest without repercussion. They have already eliminated that with the previous Human Security Act, that there's a 1 million fine every
500,000.
500,000 every day that you are illegally detained for wrongful persecution of terrorism. That's already eliminated in the current anti-terror law.
Just when it comes to arrest, searches and seizures, always be aware of what your rights are. And as much as possible, do not try to escalate the situation. Kasi I don't think anything good comes out of escalating it. If you're being arrested and you have determined na valid naman na police officers talaga, and someone is there naman to testify na inaresto ka, preferably family mo na nakita na inuhuli ka, just cooperate with the arrest. Kasi if there is something illegal with it, it can be a defense. It will be your defense when the case is filed. And also, there's no point in arguing with law enforcement officers at that situation kasi they're only doing their jobs na ina-effect lang yung arrest. And any conversation to ease the arrest or hindi ka huliin can be taken as a corruption of public officer. Always be aware of your rights and always know what to do when you are being arrested or being searched.
So there you have it. That is the first episode of Reasonable Doubt, a new podcast. In the second episode, we are going to discuss protests at the time of pandemic. Please like and subscribe to our YouTube channel. And if you have some topics that you want to discuss, please leave a message and we are very glad to answer your request. Thank you.